Hello, hello. Hello, hello, everyone. All right, everyone, put in the chat where you're zooming in from. Hey, Nancy. Hey, CA. Jody and Tara. Let's see. Who do we got? Who do we got? Seattle, South Jersey, Ithaca, Vegas, Baltimore, Wichita. I've been to Wichita. Denver, Eastern PA, Florida, Philly, but in California. Sydney, welcome back. And that's Sydney, the human, not the city. Sydney from Seattle. And South Philly, yay. Represent Vermont. All right. So let's dive right in because there may be a lot of questions. Let me see. Let me find the PDF. All right. And this is the first time I've seen you guys since Thanksgiving, so hope everyone had a lovely Thanksgiving and long holiday. So, housekeeping as usual, and I don't need to tell this group because we're awesome and respectful and kind as a default, but mute your mic because there's a lot of folks and there'll be a lot of questions. And as always, be respectful and kind as other people are speaking. The agenda for the meeting, we'll talk about the Exclusive Citizenship Act, which was newly introduced just a few days ago. Yet the, newest iteration, if you will, of the shit showness that is the US government at the moment. And also Sandra Munez update. I'll remind you guys who Sandra Munez is if you don't remember. Looking for a pen, sorry. All right, got one. A Sandra Munez update. We spoke on Sunday, so that went really well. And also our next legal queer and A, because I will be in Iceland December 21st through the 28th. So the 23rd, I think, would be the next legal queer and A. So it's actually going to be on a Monday at 2:30. Totally random. Only the diehard LQA folks are going to make it for that because you're going to have to remember that it's on a Monday and not even close to noon. So, but I wanted to have one before the end of the year to do a wrap up as far as just everything that has gone on, maybe not everything that has gone on in the year, but sort of a macro level 2025 wrap up, if you will. And maybe I'll take a poll. I don't know, Jen. Maybe we'll take a poll and see if it's worth doing it on that Monday, and or just wait till the new year. But I will let you guys know. And so, as far as who I am an LGBTQ estate planning attorney. I started out as an international human rights lawyer and worked at the War Crimes Tribunal for the Rwandan genocide. And then when I moved back to the US, realized that one of the human rights issues right here in the US was LGBTQ issues and coming from a Canadian perspective. So I too am a dual citizen. So I come at the particular topic that we are discussing today from a very invested place because I was born in the United States. But when I was two, very young, I don't even remember, we moved to Quebec, where my mom is from. And in Canada, you are automatically what your mother is. It follows the maternal bloodline. So I have passport and citizenship documents and all of the things. Um, and so we always do an estate planning tip. If this is your first legal queer and A, we always do an estate planning tip. And since we're talking about international and moving out of the country and all of the things, one of the biggest questions that I get from my expat clients and or people, especially in the last year, that are looking to get their go bag ready is, will my US estate plan be valid if I move to another country? So the answer is it depends to what extent you are becoming a permanent citizen and or resident of that country. So if you were to just move right now to a country where, let's say, they give you a year-long visa-free stay, Albania, there are multiple countries where you can just go and stay visa-free for 6 months to a year. You're a US citizen who happens to be in another country. So your documents will be valid. Okay. But what I've seen at unprecedented levels in the last year are folks that have significant US touch points and assets still in the United States, but are leaving indefinitely. Okay, so once you leave indefinitely and or become a resident, permanent resident, and or a citizen of another country, your US estate plan will still govern what you have jurisdictionally within the United States. Your 401k, your brokerage accounts, your real estate, your bank accounts, whatever you have that ultimately is still in the United States, your US estate plan will govern. And the need for revocable trust, if you don't already have one, is now basically mandatory. And then if you've moved to Portugal and you're becoming a, Portuguese resident and or citizen, then you'll want to find the counterpart of me, the Portuguese counterpart of me. I mean, there is no counterpart of me, but to the extent that you could find a counterpart of me, you would want to do so in that country. And then I work with that attorney in that country to see, because the US has treaties, probate treaties with countries, and then we need to look at that country. So I always tell folks, choose whatever country that you want to end up in. We work backwards from that. And once you know what country you want to be in, then we look at the treaty from that particular country and the United States, and then figure out how we need to make sure that the two estate plans don't conflict, counteract one another, Ghostbusters, the green lines. You want to make sure that you don't have that going on, and then that implodes and you have an international probate nightmare on your hands. So, is it valid? Yes. Is it all you need? Potentially not. Okay. And then the 9 LGBTQ estate planning documents that I recommend: your healthcare power of attorney with HIPAA, your living will, your hospital visitation authorization form, very important, especially for international travel. The 3 legal financial, your DPOA, of which I give you 3 each, your last will and testament, your revocable living trust, very mandatory, no longer optional at this point. And then the 3, what I call companion documents, your pet care directive, very important, along with your disposition of remains, and then your tangible personal property memorandum. All right, so we'll jump right in. The Exclusive Citizenship Act, it was just introduced December 1st, just a few days ago, and by Bernie Moreno in Ohio, seeking to ban dual citizen or multiple citizenship in the United States. So direct language from the act: an individual may not be a citizen or a national of the United States while simultaneously possessing any foreign citizenship. So it would force current dual citizens like myself and millions of others. So experts, there's no database as of now that is keeping track of dual citizens. And that would be one of the issues and one of the enforcement problems with this legislation. But we have no way of knowing, but anywhere from 500,000 to 5.5 million folks like myself that would be impacted. So it would force current dual citizens to choose within 1 year from the enactment of the law whether or not, so if you're a US citizen and a citizen of another country at the same time, you'd have 1 year to renounce the foreign citizenship and notify the US Secretary of State, or formally renounce your US citizenship to DHS. So one or the other. Either write to the foreign country and renounce and notify the Secretary of State that you have done so, and or formally renounce your US citizenship. If you don't comply, so if I did nothing in that year, I didn't renounce to Canada and I didn't formally renounce my US citizenship, then the law states de facto I will have been deemed to have voluntarily relinquished my US citizenship. Okay. And then you're considered a foreign alien and therefore at risk of deportation, just like anyone else. So if a U.S. citizen acquires a foreign citizenship after the enactment, what a lot of folks are in the process of trying to do, in the spirit of getting the go bag ready, then once you get that foreign citizenship, you will have automatically been deemed to treated or deemed to and treated as having given up your U.S. citizenship. So one of the things that then the Department of State and DHS would be empowered to do is build yet another list, yet another enforcement system. So within 180 days of enactment of the law, the Department of State and DHS would create regulations, verification systems, and a database to track those who have renounced and those who have been deemed to have relinquished their U.S. citizenship, and now they're considered non-citizens in a federal system. Okay. So a lot of people have been messaging me, emailing me, how could this be true? Ultimately, the very president's wife and son would be impacted. Yes. A lot of high profile and very rich Americans would be impacted by this. Again, one of the reasons why they think this won't gain traction in the Senate, but we ultimately can't be sure. And just being married to the president, ultimately they would get a pass, but not necessarily the other very, very influential and rich Americans that this would impact. So, in no way is this law right now. It was just introduced on December 1st. It was read in to the Senate and referred to committee for further discussion, analysis from a feasibility standpoint. Again, there is no database. How do they know that I exist, that I have this Canadian citizenship? If I don't comply within a year, how would they know, right? So there's a lot of feasibility issues as of right now. And we don't know yet. The news hasn't picked up on whether or not there's any co-sponsorship or any traction in the House as of yet. In other words, are other Republicans for this, and will it get momentum by other Republicans? So, as of right now, there are no immediate legal consequences for anybody, and no one is being asked to choose, register, or renounce anything as a result of this bill having been introduced at this time right now. So, there are serious constitutional problems with the bill as written and what it's seeking to do. Okay, which is a good thing, but at the end of the day, the constitutional issue could be dealt with in court. That doesn't mean that the bill wouldn't necessarily become law, and then we'd have to sue in order to, bring the constitutional problems to the forefront. So the main core issue is for at least over 50 years, we've had SCOTUS Supreme Court precedent that Congress in and of itself cannot be empowered to take away U.S. citizenship without the individual's real consent and intent. And Afroyim is the one case that delved into intent, the intent to relinquish U.S. citizenship. So in the Afroyim case, the Supreme Court held that under the 14th Amendment, Congress has no power to revoke a U.S. citizen's citizenship unless that person voluntarily relinquishes it and had intent to do so. They wanted to relinquish their U.S. citizenship. And then Vance, not that Vance, a different Vance. In that Supreme Court case, the Supreme Court held that the government must prove both the two things, that the person did the act of relinquishing and that they intended to relinquish and or give up their citizenship. And this is important with this particular law and the way it is written. That intent cannot be presumed. Now, the case doesn't say this blatantly. It's read into based on the precedent. Okay, so that the intent cannot be presumed just because they did some act on a statutory list. In other words, if within 1 year from enactment, I have to comply with the statute by doing a thing, and then I don't do that thing, I can't be presumed to have relinquished because I didn't do the thing. Okay, so you actually have to relinquish and have the intent to want to relinquish. And and so again, these are two, decided far apart, 30 some odd years apart, and going back 50 years, right, from today. But this bill would have to survive two Supreme Court cases that have built upon one another. The first one said that you have to voluntarily do it, and then the other that the intent cannot be implied. So, as far as comparing the two Supreme Court cases that are currently in existence with what this bill is trying to do, Marino is trying to get around the SCOTUS precedent by saying if you fail to file the paperwork, so you did not do a thing, right? You didn't file paperwork within the 1 year, you have then been deemed to have voluntarily relinquished US citizenship. So, and that is the exact kind of fictional consent that both of those Supreme Court cases were addressing, but not completely on point. Okay, so it's not like there was a bill like this 50 years ago and it was sued. So different facts, but ultimately could be read for precedent to deem Marino's bill unconstitutional on its face. Now, again, even if it is deemed unconstitutional, doesn't mean that it can't be introduced into law. But so here, legal scholars are saying that the bill is flatly inconsistent with these two decisions and therefore unconstitutional on its face. So if passed, right, because just because legal scholars are looking at the meat and substance of the bill and saying it's unconstitutional, doesn't mean that it won't pass and come into law. But then civil rights and immigration groups would file lawsuits immediately. And we had that Supreme Court case over the summer that said that executive orders by Trump automatically become law until the Supreme Court says otherwise. This would not fall under that. So federal courts would issue an injunction right away, blocking enforcement, and it would not go into effect until the Supreme Court dealt with it. So while Trump sort of has carte blanche as president for executive orders and other things that he enacts that automatically become law and go into effect until it reaches the Supreme Court, this would be Congress. And so therefore an injunction would hold. There would be, again, no legality until the Supreme Court dealt with it. Then the Supreme Court would be asked to either overturn two long-standing 50-year Supreme Court precedent, which would be a huge shift, and or strike down Marino's law. So what are the political and practical likelihood of this bill passing? It would be radically, radically disruptive. It would force millions of Americans, including US-born folks like myself, who inherited a second citizenship, longtime naturalized citizens who are from a country that allows them to keep their original citizenship, and then children with dual nationality from birth to choose one or the other, potentially losing family ties, probate inheritance rights. Massively, massively disruptive. Property rights, right? I have clients who own property, but as a citizen of that country, Poland, France, Italy comes to mind, of Mexico. I have a ton of clients with that are citizens of and own property in Mexico, but they're also citizens here. Well, the property rights as a Mexican citizen, that property passes to their family in Mexico differently than if it were just me who happened to own land in Mexico. Okay, so all of that would be disrupted. Unpopular with key constituencies. So I picked one that didn't have you know who in it, even though these two aren't that great either. But so this may not be very popular amongst a lot of Republicans either, right? So it catches in the nets. Lots of people in military families, businesses, CEOs of Fortune 100 companies, and tech companies, athletes. Over 25% of our professional, especially the NBA and hockey, mainly from Canada, they'd all be caught in the crosshairs, right? And obviously the Trump family itself, although they would get sovereignty, but still. And obviously business, higher ed, college, professors, university, the students. So many people would be caught in the crosshairs, and obviously immigrant communities would fiercely oppose it. Enforcement, not again, not that they care, but enforcement is a logistical nightmare. Okay, so to actually implement this, and they're in the midst of talking about it, that's why there hasn't been a lot of news, is it came to light on December 1st, and it was read right away, which is not good news. It was read it's already in committee 8 days later. All right, so that's not great news, but at the end of the day, the logistical nightmare of bringing this about, a national registry, again, nobody knows, right? I didn't never had to file anything within the United States that says that I have a Canadian citizenship, right? So how would they create said national registry? Data sharing agreements. There's 195 sovereign countries out there that fly a flag, right? So for this to actually take effect, all of those countries, most of which hate us right now, would have to voluntarily want to share information with us about citizens of their country ultimately. And we're just going to demand that they do that. So diplomatically, that will be a heavy lift given where we stand diplomatically in the world. And then new bureaucracies around citizenship termination processes. In other words, due process, right? If your citizenship is terminated and you want to appeal that, right? Like there's a whole process that doesn't exist right now that bureaucracies would have to be created around a citizenship termination process. Um, and immigration practitioners point out that this is borderline impossible and would create enormous administrative chaos. I mean, folks said that with going from marriage equality, from not having marriage to allowing for marriage equality, and like the administrative burden, they allowed us to go back and amend our taxes 3 years after marriage equality hit, and they thought that the administrative chaos that would create. So I don't hang my hat on that last piece, but you know, it is in fact true. It would be administrative chaos. Whether or not it's borderline impossible or not, I don't know, and I don't know to the extent how much they care. Again, a lot of this is, and that goes to my next slide, billboard politics. Right? It's a great term, just even the visual of it, a billboard, advertising, marketing something, right? And so calling this a billboard politic move, in other words, just wanting to put out there the idea that he stands for, Marino in particular, and anyone who co-sponsors and or supports this bill, that they stand for America first, toughness, that there may be no traction behind it, that it won't actually maybe get out of committee and or may not gain traction on the House floor. It may not leave the House. If it does leave the House, will it get through Senate, right? So there's a lot that needs to happen. But did he just do this in order to gain notoriety with his constituency and put a big billboard out there that I stand for America first? So there are two things at play here. The first one, the most important, are the legal odds of it passing. Because again, the law itself could be enacted and go into law, but then is it legal? is it constitutional? So the legal odds of it passing are low. It is on a direct collision course with two Supreme Court cases that rest and say that the Supreme Court, and again, the Supreme Court, and I've gotten this question as well, the Supreme Court that had decided that case in 1980 and in 1967 is not the Supreme Court that we have today. However, the Supreme Court that we have today, this is not a hotbed issue for this particular Supreme Court. This is not something that this Supreme Court, like marriage equality, right, like abortion, like other things, at the end of the day, taking away you, well, I mean, they did just agree to accept the birthright citizenship case. That is different than this. So I'm scared to see how we'll talk about that at another LQA, but once oral arguments are heard and we have more of a sense, that will definitely be a topic. But the Supreme Court did just agree to hear the birthright citizenship case. This is different from that. Okay, so legal odds of it being deemed constitutional if it does become law, low. And then the political odds of it getting out of committee, of it getting out of the House, of it being enacted by this particular Senate. Disruptive, unpopular with folks with powerful interests, Fortune 100 companies, high-level universities, tech industry, AI industry, huge, and just extremely hard to administer. So bottom line, in my opinion, and again, preface all of this with this is my opinion, after having done significant, like 8-9 hours worth of research on this, again, as a dual citizen myself, very interested and impacted by this. So I did the research both for you and for me. But while nothing is ever impossible, especially given the politics in the world in which we live now, in my opinion, a realistic assessment of the legal and immigration world that we live in, it is highly unlikely to become enforceable law. It may pass, and then there'd be lawsuits, and then it would be halted by injunction, and then it would work its way up to the Supreme Court. And I can't envision a Supreme Court, even this one, overturning those two major Supreme Court cases. Okay. And then the next legal Q&A, like I said, December 29th, 2:30 p.m. We will do a wrap up of the year, sort of a high level macro, try to end it on a positive note, even though a lot of crappy things have happened in 2025. And also, and I forgot the Sandra Munez update. So again, Sandra Munez is the Supreme Court plaintiff in the Department of State v. Munez, which when we were going over the Kim Davis case, and whether or not the Supreme Court was going to hear the Kim Davis case, I, in doing a lot of research just around marriage equality in cases that exist now and cases that have been decided, even I, up until 7-8 months ago, hadn't heard of the Department of State v. Munez, which is an immigration case about a straight married couple who, for the first time in U.S. history, an American citizen, had their spouse deported. Now, she did not have the spouse deported. The American government deported her spouse. And that had never happened before. If you remember the 1970s movie Green Card with Gérard Depardieu, right? It has always been long-standing U.S. law that if an American citizen marries somebody, then that spouse cannot be taken away from them, cannot be deported, that they're basically safe here, right? So you've known, I'm sure, a lot of folks that it's like, oh, well, you were here on vacation from Brazil, we met, we want to keep dating, and the only way to keep dating is to get married, so that way you don't have to go back. No longer the case, and a lot of folks have, reached out, well, if the Supreme Court, Amy Coney Barrett, wrote the opinion, and folks have reached out, well, if it was about a straight married couple, aren't straight people impacted by this case as well? Yes, marginalized families, Black, brown, straight people, and queer families, ultimately. right? Because through immigration and deportation and all of the things. So, in the opinion, Amy Coney Barrett's written opinion was massively broad. Even the Neil Gorsuch wrote a concurring opinion saying, "What are we doing here? Why are we even hearing this case?" And I asked Sandra Muniz, we met on Sunday to talk about it. So I reached out to her and said, because I view this case as being the case that the Supreme Court cites moving forward to chip away at a Obergefell, that there won't be a massive overturning of Obergefell, that instead there will be a slow erosion of Obergefell. And in that case, Amy Coney Barrett found a way to make this immigration case about a straight couple about marriage equality. The dissent, Sotomayor, Ketanji Jackson, the Kagan, the dissent was like, how did you make this about marriage equality? Right. And so Sandra Muniz is an attorney, employment discrimination attorney, well connected. She knew folks and she could afford and knew folks, and that's why this went all the way up to the Supreme Court. And so, just as a lawyer in the world, I reached out to her and asked, I've done some research, and it's possible that your case will be cited moving forward to chip away at the rights inherent in marriage equality. What are your thoughts? And she said, she emailed back, I certainly hope you're wrong, but I can see how you're right at the same time. And so we met on Sunday to talk about it. She said that even in the hearing with, the actual oral arguments, that, here, I'll stop share, that during the oral arguments, that Neil Gorsuch even said, I still don't understand why we're here. Neil Gorsuch, dissent amongst the ranks, literally was like, I don't understand why we're here. Because one of the things is with the Supreme Court is you only get to go to the Supreme Court if there's an issue to be decided. And so her main issue, which she hung her hat on for over a decade, he was deported close to 10 years ago at this point. And the case just came down June of 2024, 18 months ago. So it took a very long time for it to go through the court process. The Supreme Court agreed and granted cert January of 24, and we had a decision by June of 24. And um, one of her issues was due process, that her husband was deported without her being given a reason why. Due process, like one of the enforceability issues with this particular law, the bureaucracy around it. So she said, you actually deported my husband, and I don't even know why. Well, months before the Supreme Court granted cert, she was told why. And it was because he had suspicious tattoos. He's from El Salvador, and that ultimately he was thought to be a gang member, suspected gang member based on his suspicious tattoos, and that was the reason why. But then the Supreme Court took the case anyways. Well, the issue around due process was over. She was told why. And yet the Supreme Court still took the case. And then Amy Coney Barrett made it about marriage equality. And Sandra Muniz said that she was shocked in the oral arguments when Neil Gorsuch said, why are we even here? And then when they got the opinion, then they realized, oh, wow, this is so broad and so overreaching that that's why they took the case. And Neil Gorsuch wrote a concurring opinion, again saying, I agree with the final judgment. He should have been deported, but we never should have taken this case. This was an overreach. So Sandra Muniz has agreed to do a more formal interview, talk about her case, what has happened since the decision came down in her life in the last 18 months, her thoughts around the holding and how it is being used by the Supreme Court around marriage equality. And then we'll also delve into the birthright citizenship issue, which is now they just have agreed to hear that. So we'll get her take on that. So that is the Sandra Muniz update. But I will take now any and all questions on the Exclusive Citizenship Act that you may have specific to you. Jen, is there anything in the chat?
Yeah, there's a few in the chat. Do you want me to read them to you or you want to scroll through?
I just found them. Um,
And I put them all in the document as well.
okay. Um, remind me to come back at the end to the revocable trust and why that's required now. Um, and it's not like legally required. It's just from my um, perspective, it's required. What about a permanent residency in Mexico as a status? It is not citizenship, but should I be concerned? If we go down this slippery slope, yes. I mean, this law in particular is exactly what it sounds like, the Exclusive Citizenship Act. So it's around citizenship, but permanent residency here in the United States gives you the same abilities and rights and whatnot as a citizen. So, except in different countries, voting is a big one. So, on its face, based on the law and how it's written, the answer is no. Should I be concerned? That's a slippery slope question. I would say yes. Keep your, thumb on the pulse of it. I will be updating folks as this goes on, but ultimately, concern, but on its face, not a problem based on the letter of the law. Um, hello from Ireland. Um, who sponsored this? Bill Marino out of Ohio, Republican from Ohio. If we are in the process, should we stop? I wouldn't stop. I would continue because, again, if it does become law, and let's just say the Supreme Court um, does not find it unconstitutional and reverses its decisions in the earlier two Supreme Court cases, you will have that 1 year to decide. But if you don't move forward and get it, you don't have a decision to make ultimately. So I would go ahead, keep doing what you're doing. And then if it's all for naught because you choose to relinquish, your Irish citizenship that you just got, but if you don't have it, you don't have it. Yeah, I exactly. Given the current composition, could this be passed? So two things. I don't view this current composition as being birthright. Totally different story with, and oral arguments will tell us a lot there. This is different from that. And with the current composition of the court, I'm not that concerned. So that's one thing, is just the composition of the court and the fact that we've seen this court make political decisions, right? Rule of law is gone. It doesn't matter anymore whether or not, a case, just like the Department of State v. Muniz, that was jurisprudential gymnastics. It was absolute BS. They should not have taken the case. They shouldn't have written such an overbroad opinion, but they did it because of wanting to basically create legislation from the bench, right? So the Supreme Court is not above doing that, and they don't respect the rule of law. I don't see this issue as being a hotbed issue for them, A. B, it would be a jurisprudential gymnastic feat for them to get around those two other cases. So in my review of those two cases, I don't see how they hold this law and deem it to be constitutional and and basically align that decision with those two cases. How they get around the 1967-1980 case and the two-prong test of voluntarily and showing intent. So I don't. So that's a two-part question. Is the current composition such that that they would want to legislate that from the bench? And even if they did, even if this was a marriage equality issue, because there are those two cases, they'd have to find a way legally around that. And I'm sure there's a way. I'd have to delve further into it, but I don't believe so. Can you please explain the difference between permanent citizenship? Really depends which country you're talking about, right? Within the US, as a your executor must be minimally a permanent resident. So in doing estate planning, a executor and or trustee by law, right? Not just doesn't have to be a citizen, can be a permanent resident. Voting. So, but every country gets to define what gets what, which privileges and benefits and or rights are delineated between, and then there's resident. There's purely just a resident, then there's a permanent resident, and then there's a citizen, right? So really depends. And would these treaties all subsequently become null and void? Um, Ultimately, no. They would have to be rewritten, but you could still be an Irish now citizen owning US land, right? So if you end up renouncing and you choose Ireland over the United States, you are still an Irish citizen in Ireland that owns US land. So the treaties around probate and what happens in death and which country gets taxed, which country gets your taxes, right? So ultimately, as a US citizen, as a dual citizen in Ireland and of the US, you would be taxed differently, better, than if you were an Irish citizen living in Ireland who happened to own US land. Now, the US would want their cut. But if you were already a US citizen and like right now, the taxation would be better. If this goes into effect, you would get whacked in taxes and have double taxation, both Ireland and in the US. So the treaty itself wouldn't become null and void. They'd likely have to be rewritten. And from a tax perspective, things would look very, very different. Yes. So frustrating how much time and tax dollars go into politicians posturing, meaning the billboard politics. Absolutely. And same around trans issues, right? It's so hard to explain to, especially to trans kids and gender diverse and non-binary kids, that they're just a political pawn, that the majority of these people don't actually, in fact, hate trans folks or consider them nihilistic terrorist extremists, that it's all billboard politics, and they're staying in power because of it and feeding off of the fear that they're creating. Can it limit U.S. citizens from pursuing other countries' citizenships if they haven't already? Yes. So let's just pretend that law went into effect today. If after enactment, you then attempt to become a citizen of Mexico, once you become the citizen, Mexican citizen, you will have automatically been deemed to have foregone your US citizenship. You're welcome. Request for a topic in the future. Many LGBTQ folks deal with parents that are no contact. Can we discuss filial laws and the estate planning implications of that? Absolutely. That'll probably may not be an entire session, but it can be the estate planning tip at the beginning, the first 15, 20 minutes. Just yesterday, there's been um, a resurgence or just a surge, not a resurgence, because I deal with it having represented LGBTQ folks for the last 17 years. I deal with this a lot, but last week, a lot of new clients have this right at the outset, and why they are availing themselves to the estate planning process. A couple of them, no property right now, fairly young, but because they are no contact with their family, they are seeking the estate planning documents to protect themselves, and especially single folks, right? Like your your default person is your parent, right? And so if that's not who you would want making healthcare decisions for you and or your legal financial decisions, you're going to have to put something in writing that says otherwise. There are some countries with authoritative regimes that make it extremely hard for citizens abroad to renounce their citizenship. They put a lot of burden on the requester to the point it's impossible. So even if I was happy, still per the law, as written, the Marino one, your letter seeking to renounce from said authoritarian regime to DHS and the Department of State would qualify. That within 1 year you've notified the US government that you're attempting to do so. Whether or not they grant it, I don't think this law, they would deem you to be American. Right? You've passed their sort of American test because you've attempted to renounce said country. So in that case, I think you're good. Not sure if this was touched on, but what about U.S. permanent? Yep, we have touched on it. U.S. permanent residents that are citizens from another country. So we had Andrea who had the question about being a permanent resident of Mexico, but a U.S. citizen here. And then you're a U.S. citizen, you're a citizen of another country and a perm res here. Again, not the, if you were to become a U.S. citizen, you wanted to naturalize now and be able to vote and do all of the things, then at that point, they would ask you to renounce that country. So, as written, again, concern, but as written, you'd be safe. Also, most of us naturalized citizens had to indicate all existing. Yes, true. So, as far as a database, they have a start of the folks who, have taken the test and become. My mom was a naturalized citizen. I was 12 when she became a citizen of this country. She now lives in Canada. So, yeah, those folks, that list exists. I don't have any official papers showing that I am a dual American and French citizen. I've always wanted to get the paperwork. Yeah, I would go ahead and do it. Sooner rather than later. Do you see this as more of a means of keeping people out or keeping US citizens here? I think I think both. I think, it has not been a quiet thing that folks are getting their go bags ready, right? And so both wanting to make it clear that it's America first, and if you're a defector and you're looking to have your toe in another country in your go back, because I've been saying since November 6th, right? Like when shit's on fire is not the time to get your go bag ready. Do it now. Get your go bag ready now so that if, it hits the fan and you need to leave, that you are able to do so. And so folks have been doing so and not quietly, right? So I think it's both wanting to identify defectors, right? A uh, Department of Homeland Security advisor, LGBTQ person, it came out the other day saying like we are very much in the lavender scare Cold War era of things, right? And so just like in the Cold War lavender scare era, they wanted lists. Who are these people? The McCarthyism, right? Who are the communists? Who are anti-American? So I think it's very much about keeping people out as well as identifying who the quote unquote defectors and anti-Americans are. Enjoy your trip. Thank you, Kimberly. Very much looking forward to Iceland. Um, and so, yeah, we're almost at time. If I start the process to become a citizen, will that be interpreted? Not yet. Start the process. I don't know, honestly, that you'd be able to finalize, depending on where you are in the process, finalize it by the time this thing did become law. But again, even if it does become law, there will be lawsuits immediately. There will be an injunction, and then it'll take a year and a half, 2 years to reach its way to the Supreme Court. So you figure about a year for it to become law if it does gain traction, then a year and a half, 2 years. So you're looking at 3 years, kind of making that up, 2 to 3 years, right? Give or take. And I'll have my pulse on this, so I'll let you know if it's sooner, but it could only be later. So I go through the process of whether it's through your hereditary, your ancestry, money paying, for a golden visa, whatever means you have for your go bag. I would continue the process and then you could halt it and or relinquish it. But I'd rather you have the option. I'd rather you have choices than not. Um, yes. My son, sorry, read what I'm saying yes to. My son and my sister have two passports. Will they be asked to relinquish the non-US passport? Yes. I have two passports. I would be asked to choose between the two. Maybe you covered this, but how does this impact revocable trusts owned by couples where one is a dual citizen and the other? Um, so it's not some, so I didn't get into the revocable trust piece, but I have a revocable trust. I'm a dual citizen. I am here in the United States. If the only It doesn't impact my revocable trust here and or you with your husband as being co-trustees with someone that has two passports and or two citizenships. Um, but if your husband does not relinquish, if this becomes law and then he does not relinquish the other country's citizenship, then he becomes a foreign alien on US soil and faces deportation. If I get deported to Canada and now I'm living in Quebec, I'm living in Montreal, and I have a US revocable trust that has my property, my real estate in it, that doesn't change anything except from a tax perspective because again, the treaties between US and Canada, I am now a full-blown Canadian who happens to own real estate in the United States. When I die, because I'm not a US citizen, the US is going to want their pound of flesh from a tax perspective. And then as will Canada, because now I'm dead. And then my Canadian family will then inherit said money. And so then Canada will want their pound of flesh. So now we have double taxation, right? So it doesn't impact how the revocable trust will help you avoid probate. That will still happen, but revocable trusts are a probate avoidance tool. They don't deflect and or avoid taxes, or else nobody would pay taxes. Okay, if it were that easy. So in the few minutes that we have left, I'll talk about the revocable trust, why it is no longer optional. This is your revocable living trust. Anyone who is a client of mine knows that I always have a glass of water nearby. And this is your revocable living trust. The water are your assets. So as James mentioned, James has real estate. James is a client, he and his husband. They need to put their property and their businesses, right? So this is a probate avoidance tool, right? If everything that made up who you are had just beneficiary designation forms, 401k, Roth IRA, 403bs, you name it, anything with a beneficiary designation form automatically avoids probate. The asset is the 401k. The probate avoidance tool is the beneficiary designation form. This, your real estate has a deed, it has title. This law firm is an LLC, it has membership interests. They don't have beneficiary designation forms. The most common American-owned asset is real estate. The second most common is a business. I have both. I trigger the two most common American-owned assets that pulls an estate unknowingly, unbeknownst to most Americans, into the probate process. Okay, so we'll talk about probate on another day. We'll just do estate planning as an LQA, but just probate is a lengthy, costly court proceeding. To the extent that we can avoid a lengthy, costly court proceeding, we want to. And your revocable living trust is that probate avoidance tool. The only way for real estate to avoid probate is to retitle it after we do your estate planning, to retitle your real estate into the name of the trust. So if the deed says Andrea Giampolo on the deed, when all is said and done, when we've done proper estate planning, my deed should read the revocable living trust of Andrea Giampolo. Why post-election? These are now no longer optional. What does the election and probate avoidance have anything to do with one another? The revocable living trust is what we've been using as LGBTQ folks for decades to recreate a marriage. Okay, so a creative LGBTQ lawyer saw it wasn't created by us for us. It was created for probate avoidance for everyone, gay or straight. But a creative LGBTQ lawyer 50 years ago saw how this operated in everyday life and went, huh, we don't have a way of binding ourselves together in the bonds of matrimony. But if we become co-trustees, co-CEOs of one another's lives 24/7, it creates an impenetrable, inseverable legal bond. 100 times more powerful than marriage because there is no power inherent in marriage. There is only privilege. 1,138 state and federal privileges, but they are just that, privileges. So it is revocable. We can sever it. But hostile family members, which 50 years ago happened a lot more than it does now. But 50 years ago, we were invisible to the government, right? AIDS? What? Huh? Right? We were invisible. They pretended like we didn't exist. But now we're very visible. So while you may not have a hostile family member, everybody, 100% of LGBTQ folks in this country has a hostile government. So if your marriage, if your relationship is like a castle, the revocable trust is a moat around your castle. Doesn't matter what state you live in. All right. One of the most fiscally advantageous privileges tied to marriage is automatic probate avoidance upon the first of you to die. The government knows probate sucks. They created it to make money, right? So they said one of the 1,138 state and federal privileges for married couples is we will give you one freebie. We'll give you one freebie. But LGBTQ folks, we didn't have that freebie 50 years ago. So one person dies, probate to the other, even if they were together 47 years. Then that was the Edie Windsor case. Then the survivor dies, probate. So at a time when we had double probate avoidance, this allowed, or double probate, this allowed us to claw back one of the most fiscally advantageous privileges tied to marriage and give us double probate avoidance. So gave us a bond 100 times more powerful than marriage that nobody, not even the government, could sever, created a joint repository for all of our assets, and at a time when we had double probate, allowed us to claw back the most fiscally advantageous privilege tied to marriage, probate avoidance. So, as a marriage recreation tool, or if you are legally married now and in a state, in a good state, in a blue state, right, it is your marriage protection tool. If you're in a red state, it could be your marriage recreation tool if a Obergefell gets overturned. So, in from an estate planning perspective, I've always deemed them to be mandatory and as part of my basic estate planning package because nobody should want to go through probate. Okay, again, this was created 100 years ago, not by us for us, but by folks who wanted to avoid a lengthy, costly court proceeding. And then we adopted it as a marriage recreation tool. So post election, whether folks are 24 renting a 300 square foot apartment or 65 and multiple properties in multiple states and just one property, everybody is getting the revocable trust as a marriage recreation tool. Okay. So that was that one question at the beginning about why no longer optional. Um, if we're already married and have legal DPOA, should we? Yes, I just explained why. The DPOA expires at death, people. Your durable power of attorney is the most important document while you're alive. Effective immediately upon notarization, or it should be. It should not be a springing power of attorney. Okay, and again, we can talk about that in a longer LQA around estate planning. But springing powers of attorney are no longer accepted by big box banks, Chases, Wells Fargo's. Springing means it springs into effect upon the occurrence of a thing, which is typically disability. Big box banks, as of 4 or 5 years ago, said we don't want to be in the business of deciding that the event has sprung. We're not lawyers. We don't go to court and get me a court decree saying that the event has sprung. Well, why do your estate planning if you then have to go to court to prove that the event has sprung? So I don't do springings, but your durable power of attorney is effective immediately upon notarization, never expires, expires at death, and then the will and the trust kick in. So having a DPOA in no way replaces the need for revocable trust because it expires at death and then this kicks in as your probate avoidance tool. All right. Good. I'm glad, Liz. And yeah, reach out with any additional questions. We will email you after I discuss with Jen, because Jen knows I like to change my mind, just like we weren't supposed to meet today. And now we are. We'll let you know about December 29th. Also, email me if you do want to meet one more time before the end of the year. I'll make it happen. The 29th would be the day. So weigh in an informal poll, and then we'll reach out. Okay. So happy Tuesday. They're better than Tuesdays. And I'll see you guys soon. Bye.